And we're live. What's up, everybody? It is Andrew Esquire, the legal mindset. We teach you to be your own judge. Good to see you today on a Wednesday morning. Let's go, baby. We're here to talk about this here today live. I got my water here. I'm feeling much better. My voice is recovering, but it may get a little dry here. So we're going to try to stay well lubricated here on the legal mindset. This is a live, guys. So those who are wondering, this is a live, not a premiere. So we are live in the house. Good to see everybody up in the hizzy today. Let me give a special shout out to all of the members in the chat that I see so far, the green names, the members of the Base Legal Mindset or the Replay Gang, my membership programs. That is Danielle, Onawal, Grant Rasha. We got Mamasaurus, Rex, Lele. How's it going? Legendary Racing, Incoherent Turd. Who else we got up in here? I think Ted Park. Good to see you, Ted Park, as well. And all those that are coming in here to join us as part of the BLM RPG. Not K as well. I saw Not K earlier. And Patrick Kennedy, what's going on? Make sure you smash a like on the way in and say hi. Solid State Citizen, what's going on as well? Good, yeah, good to see everybody here in the chat. We're already at 152, which is amazing. Guys, for my channel, which constantly gets disincentivized in the algorithm, gets shadow banned, gets hate, we're doing pretty good. We're always doing pretty good. Smash a thumbs up, share it out. We're going in depth today on the summary judgment motion. So this is probably going to be the end of the state case. I have a strong feeling that this may be it. So I wanted to spend time here because this may be the penultimate saga to the Disney story, and really nobody is covering it. I know that other people have kind of broke the news, but you know, there's breaking the news and just saying, okay, well, there's a summary judgment motion. Okay, well, none of those folks are Florida lawyers, know anything about Florida law, and certainly they're not going to go in depth as I'm going to go in today and give you guys like real in-depth, like here's the real knowledge of Florida property law for this specific case and this specific motion and what they're talking about here, which is what we're going to do. And thank you for all those that are giving support here. Michelle Morgan says, I love your show. Thank you so much. Appreciate all you. Appreciate all the support for the channel. And everybody who's jumping in here. Yeah, I've seen some other people, other channels that cover Disney stuff, they've broken that there's a summary judgment motion, but you know, a lot of the people that break the news, they're not lawyers, right? And so they can break the news, they can say, okay, this is a development, but they don't understand what it means. And they really don't understand how this is a checkmate. They really don't understand the ramifications here, because when this drops, here's what's going to happen. Disney's going to lose the state case. And then they'll say, oh, well, it's just a state case. It's biased for DeSantis. And then they'll lose the federal case. And then they'll get egg on their face. And then they'll be covering. And then they'll be griping. And then they'll be moaning. And then they'll be complaining about all the horrible things that are going to happen to them in Florida and how they can't do business in Florida anymore, how they're going to have to scale back and pull out. It's going to be crazy. The leading case on summary judgment in Florida is Volusia County versus Aberdeen. My first case I worked on in Florida. Very nice. The Gaz in the chat. Appreciate you, Stephen Gosney, hanging out in the chat. My good Florida man friend. And those people checking in here, those members checking in. Aaron Hack, good to see you. And Darren Bennett, good to see you as well. All right. So let's pop it up right here so you guys see what I'm talking about. So this is what I am talking about. This is the motion we're going to be getting into and going into in-depth today, which is filed August 15th at 2:55 p.m. So I guess it's the 16th over there for you guys. It's the 17th here in Asia. I live in the future. But this is a filing in the state case of the Central Florida Tourism Oversight District versus Disney Parks and Resorts, Inc. Case number 2023 CA 0118180. And yes, once again, guys, we are live. We are live. Do not need to ask it a million times. We're live. All right. So this is a Orange County, Florida civil case. And this is a summary judgment motion. So let me explain to you guys what summary judgment is and why it's so important. So summary judgment can effectively end a case. Summary judgment is saying, hey, before this goes to proper trial, before we go in and do the whole witness thing, you guys all know what a trial is. You watch Depp versus Heard, or you've seen, OJ or some other main trial. before we have witnesses and testimony and documents and evidence and closings and openings and counters and all this other sort of things that go on as part of trial, a lot of cases are handled on summary judgment, which is pre-trial. And that is making a motion saying, hey, before we go to trial, there is enough information, we have enough facts that we can decide this based on the law. So we can rule right away based on the legal matters and say, as a matter of law, this case is closed. We can issue a judgment and we can close the case. So you end the case early. Now, this is a good thing for a lot of people because a lot of people don't want to pay for going to trial. Now, both the district and Disney have a lot of money. Disney may have actually less money than the district because the district can just tax or issue a special assessment to get more money if they need it. Disney doesn't have that same pleasure. Now, the district filed this case in state court. So the federal case was filed by Disney. This was filed by the district. So the district really has an incentive for summary judgment here. If they can get a win without going to trial, they save money and they get what they wanted faster and right away. So this would be a massive W for them. Now, the standard for summary judgment, and this is it's a shorthand, right? Doing a very shorthand here, but you have to presume, you have to look at the material facts that are not in dispute, right? So if there's a material fact that's in dispute, you have to construe it, you have to interpret it in the favor of the non-moving party, which means the party that's not filing the summary judgment motion. So this, remember, this is a motion that can end the trial. It's just the same as a jury verdict or a case verdict. It's just the same as a verdict. In order to have that awesome power of a verdict, you need to have some presumptions if you're not going to go to trial, if you're not going to fight this out between two parties. One of those is you take everything in the light most favorable to the non-moving party. So in this case, plaintiff, you can see, is the one who's motioning. And because plaintiff is motioning and plaintiff is the district, everything has to be construed in the light most favorable to Disney. So as we go through this today, guys, as I go in depth, I'm going to be talking to you about the law, but I will actually, and I know this is just going to be, you guys hate it, but I'm going to do a devil's advocate in the light most favorable to Disney. I'm going to try to make those arguments and give you, okay, when the judge is looking at this, what is the light most favorable to Disney? What's the best scenario? So we can get an accurate assessment of whether Disney is going to win this or not. Because if you don't do that, you don't do it right with summary judgment. So let's jump right into this motion, guys. And 429 of you in the chat right now. So awesome. Make sure you guys are smashing the like button on the way in. And also, let me just put this out here too. A lot of folks over here on my locals, appreciate all those on my locals. C3 Metal, TMF Squid over there in the pig slaughterhouse. Mike likes tacos. Danielle's over there. Jay's over there. So shout out to all my locals, DGens as well. All right. So let's get right back into this. All right. So let's go into this. And I'm going to read most of it, but I may skim some of it. So this is the plaintiff's motion for summary judgment on counts 1, 2, 3, 4, and 6. So there's 5 counts they're moving for summary judgment on. Now, let me be very clear here, guys. There are 9 total counts here in this case. 9, okay? 9, 9, 9, 9, 9, like Hitler from Downfall. Very easy to remember. But each of these counts alone, by itself, is enough for Disney to lose and the district to win. This is why I am so bullish on Disney losing. And I know a lot of people think, Andrew, your titles are clickbait. They're totally clickbait. No, I'm pretty damn bullish against Disney here for the district because they only have to prevail on one. Any one of those 9 counts and Disney loses because it invalidates their contracts. And once those contracts are invalidated, it's over. It's done. GG. So they just have to win on one. Are there 9 or 9? Have it your way, Andrew. Have it your way. So let's jump right into it. For each of these counts, there's no genuine dispute as to any material fact, and the district is entitled to judgment as a matter of law. This is the summary judgment standard, guys. So when I told you about that, dispute of material fact, that's the standard. So the standard is there's no dispute as to a material fact. So when we go through these counts, I'm going to say, well, how can Disney dispute that? How can they argue that? What evidence have they presented to counter that? Let's get into the background. Prior to February 27, 2023, the district was known as Reedy Creek Improvement District, RCID. Mere days before the Florida legislature reformed RCID in its governance and changed its name to the CFTOD, the Central Florida Tourism Oversight District, RCID and the defendant, Walt Disney World Parks, entered into 2 last-minute, that's me editorializing, agreements that are the crux of this case. A 30-year Walt Disney Chapter 163 Development Agreement and the Declaration of Restrictive Covenants, collectively called the agreements. And yes, by the way, I did start 30 minutes early because I want to be able to get more in here and do more. So for those that may have gotten a notification that was a little bit early, it happens. It happens. But yeah, glad to see everybody here. 525 of you in the chat. So awesome. So these agreements were the product of backroom dealings in the face of imminent and sweeping legislative reform. Dude, blown out of the water, because this is exactly what it is. And we're going to see here how this was rushed. These agreements were rushed. These agreements were, as they say here, 11th hour, which were attempted to use to control the board into the future. So they lost control. The state took control from them, and they wanted to try to maintain that control. Shortly after its appointment, the district's new board uncovered these agreements and a host of procedural and substantive flaws that plague them. So, guys, procedure means obviously there's steps you have to follow. In Florida law, there are statutes. And statutes require very strict adherence. They're kind of like nuns. You got to do everything right or you're going to get the ruler. But with statutes, if you do not follow the exact language of that statute, it doesn't work. It's illegal. It's impermissible. And we're going to find out that in many cases is what Disney did because they were rushing. They didn't follow the statute. They didn't strictly conform to the statute. That's the problem with this, such as with proper notice. And we're going to get there. We just want to explain that. And substantive is like the actual law, like the beef. And the type of substantive law we're going to talk about. So procedural would be things like notice. Substantive is things like I told you about ultra vires. I explained this to you guys, and we're going to talk about it later on when they talk about it here. But ultra vires means beyond the powers. And I told you guys from the beginning, I've said it for a year now, that it is beyond the power of a government to delegate their governmental powers to a private industry like Disney. That is beyond the power of a government. That doesn't exist. You cannot do that. It's against Florida's substantive law. We're going to see that backed up here. So continuing here, after a public hearing during which the district heard presentation from counsel regarding the illegality of these agreements, the district adopted legislative findings detailing legal defects in the agreements and concluding the agreements were void ab initio. Disney, however, continues to insist the agreements are valid and enforceable. Yes, they do. Even in their federal case, they continue to contend this, creating doubt about the district's ability to govern. In fact, they're already fighting the district. Consequently, the district filed this lawsuit seeking a declaratory judgment saying the agreements are void and enjoining Disney from enforcing them. So that would say that those agreements, which transferred this ungodly power to Disney, are now void. And now the government has its government powers confirmed. Disney did not take those away, and Disney has to play by the rules like everybody else. So here's the 5 counts that they are going into with summary judgment. Now remember, there's 9. But as they say here, each of which independently entitles the district to the relief sought. So the district can get a declaratory judgment if they just prove one of these. So let's read through here. Number 1, count 1, failure to provide notice to the public hearing. So this is the notice thing. I've been talking about this ad nauseum. Notice. They fucked up on notice. Sorry, guys, to curse here, but they really messed up on notice because they didn't give every landowner notice. They just gave Disney and themselves notice, not every landowner. So that's count 1. Once again, by itself, that's enough to invalidate this. Number 2, Ultra Vires Act in violation of 163. That means it's beyond the powers of 163. They went beyond the law. That's what happened here. Count 3 says the district lacked the authority and jurisdiction to enter into the development agreement. And 4, violation of Article 7, Section 12 of the Florida Constitution. We're going to get into this one. This is actually the delegation of powers to a private industry. This one right here, Article 4, it violates the freaking Florida Constitution to delegate government powers to Disney. Yeah, it's a big deal. This one, I think, is really, really strong. And we're going to get to that when we scroll down to count 4. And then last, the unlawful delegation of government authority to a private entity, which is just in general and substantive law. That's wrong. So violates the Constitution, violates substantive law. You cannot delegate power of a government to an HOA. Yeah, Iger cannot be declared king, Ted. But let me get this super chat. Thank you, Rain Nation, for the $5 super chat, which says Disney couldn't do this without government approval. Both does the government and Disney need to be accountable. I offer tall trees and short ropes. Yeah, in Minecraft, of course, Rain Nation, of course. But they are being held accountable, and that's why we're doing these streams. It's why I talk about this stuff, to hold them accountable. Not everybody's doing that, guys. And frankly, most people are still out there simping for Disney, even though they are absolutely full of lies, and even though they're going to lose here. They need to be held accountable, not just in the courts, but in the court of public opinion as well. And you guys can help by that, by sharing this information out there and educating. And Jim, this is live, my friend. This is live. Last time I'm answering this question, motherfuckers. I love you all. I love you all. But Jim's my boy. Summary judgment standard. Okay. So this is the summary judgment standard, which I'm just going to read to you quickly. A party may move for summary judgment or part of each claim and defense on which summary judgment is sought. The court shall grant summary judgment if the movement, now the plaintiffs, so the district here, shows there is no genuine dispute as to any material fact and the movement is entitled to judgment as a matter of law. So we're going to get into this. This is the summary judgment rule for Florida. Okay, now you guys are triggering me. And guys, speaking of triggering, there's 656 of you in the chat and only 242 likes. Let's get up to 300 likes. Come on. Come on. And Q Revere trolls me with $10. Are we live? I hate you all. I really hate you all. Seriously. You're the worst. You're the freaking worst. Yes, you're this is pre-recorded and I'm somehow bringing up your super chats. It's so worth it. So worth it. An alibi stream. I like that. I like that. You know, where was Andrew at that time? No, he was doing a stream. All right. So that's a summary judgment standard. So they've got all these exhibits now. The exhibits they have here, the copy, the development agreement, the restrictive covenants, the declarations, these statements of these administrators and district personnel, these are all attached in a separate document. It is over 100 pages long. We are not going through that. I have gone through these sort of documents and these statements in the past. You can look at my previous streams for those, but they have ample factual support. So let me just say that everything they are saying in here, they have pretty good factual support for. Ted Park for 10 Canada bucks says, we're live, but Disney is, well, on life support, I think at best. I think on life support is where we're going. All right, so let's get into count number one, numero uno. Failure to provide notice of public hearing. So the violations alleged in counts one, I'm going to read almost the entire thing, Brandon. Calm down. Count 1, 2, 3, 4, and 6 involve no genuine dispute as to any material fact, and as explained below, entitle the district to judgment as a matter of law. For any and all of the following reasons, the court should grant summary judgment in the district's favor and rule that the district is entitled to the requested declaratory and injunctive relief. So here we go. Count one. Under Florida law, agreements entered into by public bodies which fail to comply with statutory requirements are void. Boom, baby. Void means it's as if they never existed. It's as if it wasn't even there. And a strict statutory requirement for all governments. Shit, I knew this day one walking into my job. Was you had to have proper notice. Put it out in the newspaper. Sometimes you got to mail it. Sometimes you got to mail it multiple times. Sometimes you got to put it out in the newspaper multiple times. Sometimes you got to announce a public hearing. You've got to have notice. If you don't have notice, it's just immediately void. And it says right here, the reasoning behind that is that taxpayers should not be held accountable on a contract unless the contract has been entered into according to a strict letter of the law. Otherwise, corrupt or merely inept public officials would subject the public to untold financial liability. Ladies and gentlemen of the chat, that is exactly what we have here. What we have here is Disney attempting through a corrupt and inept agreement to subject Central Florida to unlimited financial liability. That's what Disney wants. They literally want a government to be required to raise unlimited funding to pay for whatever they want to do. That is not government. That is corpocracy. Or corporatocracy? Corpocracy. Call it that one. Speaking of which, Cal Mahoney says, $10 trolls. Yes, you guys wrecking me today. You guys are absolutely wrecking me today. You dirty trolls. So that's why we have notice. We have notice because you need to know about what's going on. This is right here. To begin with, the development agreement was entered into and is subject to the Local Government Development Act, Chapter 163. These are development agreements that typically are entered into when you want to develop land and you want to get the permission beforehand to develop the land, because you say, okay, I want to do a lot of stuff over the next 10 years. So give me permission to do it. Give me all the zoning approvals. Give me everything else. And just let me go do it. So I can focus on just building stuff instead of coming back to you every time I want to update a closet. So let me just enter this development agreement. Let me get it all done up front. And that will be easier. And those are called development agreements. But there's very specific requirements for entering into a development agreement. You have to stick to the very strict requirements of this chapter. And absent the statutory authority of the act, the district could not contract away its discretionary legislative power over land use and zoning. Boom. Noting that Florida law has long prohibited contract zoning and that Florida allows development agreements only because they are expressly permitted. So there's very strict boundaries on these things. And welcome, TMC Perch, to the RPG and Ted Park. Thank you so much for the 20 gift memberships. Appreciated, much, much appreciated. We can see a sea of green in the chat with all those people in the base legal mindset. Appreciate that, and all those members out there. Thank you so much, Ted Park. Very based of you. Very, very based of you. Thank you for that. All right, continuing on here. So the intent is to authorize local governments to enter into development agreements with developers subject to the procedures and requirements of the chapter. So you have to follow the chapter. And what does the chapter say? What does it require? Well, the chapter requires very clearly that before entering into a development agreement, a local government needs to hold 2 public hearings. And notice of intent to consider that agreement shall, not may, not maybe, not should, shall, which means must, be advertised at least 7 days before each public hearing in a newspaper of general circulation, so like the Orlando Sentinel. And notice of intent to consider a development agreement shall be mailed to all affected property owners before the first public hearing. So every single entity that owns 1 square inch, every person, every business, every nonprofit, every government that's in there that owns property needs to get notice. Disney is not the only property owner. They thought they were. But oh, no, no, no. They messed up. All the land boundaries within the district boundaries are subject to maximum development program in the development agreement. The maximum development program establishes the maximum allowed development for all properties in the district. So not just Disney. So these rules are rules that are covering everybody. They're covering the hotels. They're covering the businesses. They're covering the restaurants. They're covering everything. So is it fair that Disney wanted to set the rules unilaterally for everybody with no notice? Is that American? Is that fair? No, of course that isn't. But who gets all the rights, all those governmental rights? All those rights were going to go in this illegal last hour agreement. They were going to go to Walt Disney World Resort. All of the rights. The master developer shall own and control the master development use rights and entitlements. They were going to get all of it. Now, they may assign it as they please, but that's not how it works. The government is the one that's supposed to assign those rights, not Disney. Thus, the development agreement purports to vest in Disney ownership and control of all future development within the district to the exclusion of any other property owner. So to the exclusion of the hotels, the restaurants, the businesses, everywhere else in the district. Any other property owner that wants to develop its land must first obtain a rights from Disney. So they have to grovel before the mouse. Imagine what Disney would make them do. You know what Disney would make them do? Disney would say, hey, Marriott, I know you want to add on to your hotel, but you're going to need to put up a pride flag. In fact, you're going to need to put up a pride flag and a trans flag and maybe a BLM flag. I think we're feeling a BLM flag today. And you know what? You're going to need to hire at least 20 dudes wearing princess dresses. If you're not hiring Dylan Mulvaney and 7 others wearing princess dresses. We're not going to give you those development rights. You can't actually build your expansion. Disney could do ridiculous things like that because they would have all of the power. This would be the power that Disney would have if they were allowed to get away with this, because they're not a government. They're a private entity. Darren Bennett says, thank you for all your amazing coverage on Disney and all your other content. We appreciate you. Loving life in Cebu, Philippines for the past 5 years. Awesome. And I'm so happy for you and your lovely wife and your life there in Cebu. I actually need to visit Cebu. I do plan on visiting Cebu the next couple months, probably after October when I'm doing my big thing in Japan. But yes, I do plan on being down there. So yeah, awesome. Love it. Love it. Love it. And love my fellow expats. All right. So let's continue here. Nevertheless, after holding its first public hearing, RCID violated Chapter 163's mandatory notice. Specifically, Disney did not mail notice of intent to consider a development agreement to these other property owners. So they did not give any notice to anybody else other than Disney. And because of that, and that alone, the development agreement is void and unenforceable. So guys, right there alone, the district wins, Disney loses. One count. Now, okay, I know what you guys are going to say right now. They're going to say, okay, well, you said light most favorable to the district, to Disney, right? Because it's a summary judgment motion. So we have to take the facts, since the district is trying to win over Disney, we have to take Disney's side. We have to do what's called steel manning, which is taking up the best possible position for Disney. But here's the thing, guys. If Disney didn't do it, there's no best possible scenario for Disney. Disney has to show that they mailed out notice to all property owners. They have not showed that. They have not sent in any copies of notice that they sent to all property owners. They haven't showed it. You know why? Because they didn't do it. So there is no light favorable to Disney because there's no facts that support that. And you need to. I worked in government. I can tell you guys, hand to God here, you have to be able to prove you sent notice. We keep triplicate copies. We keep the physical copy and 2 digital copies of every notice because it is so important to making sure what you're doing is legal. So this is the thing that alone, even interpreting in light most favorable to Disney, Disney is screwed. Just on notice. Count 1, they've already lost. But we have to go on because, of course, the show isn't over there, guys. And, of course, that makes it null and void. So they're entitled to a judgment as a matter of law based on count 1 and count 1 alone, because that invalidates both the development agreements and the restrictive covenants, which are attached to that. And once again, yes, it was RCID that needed to send it, and that's back when RCID was controlled by Disney, right? So they messed up. They did not do that. Take a sip of water. Okay. All right. I can handle that. I can handle some water. And no, I did not get my glasses back from Nick. Nick still has my glasses. The beef continues. All right. Next, the thing I've been talking about forever, ultra vires. Dun, dun, dun. I love this. It's one of my favorite. It sounds like almost from like My Hero Academia. Like, what is it? Oh God. Like ultra, like whatever, plus ultra, whatever it is. It's just, it's over the top here. But ultra vires means beyond the power. So the act provides that any local government may, by ordinance, establish procedures and requirements as provided in 163 to consider and enter into a development agreement. So you can enact these development agreements by ordinance. But the key word is here, by ordinance. An ordinance is a properly enacted law of a municipality, right? just like a bill, right? So it's like a true bill. So you can enact something by legislation. Ordinance is like legislation for a city or a county. So ordinance, think of it the same way as a law, right? But you remember, there's steps to enact the law. You guys know what it is. First, it goes to the House of Representatives, the Senate, then it goes to the signed by the president, yada, yada. All that stuff, all that good constitutional stuff, all those steps it has to go through. Well, local governments have the same rules. And you have to have a public hearing. You have to have comment, open comment. You have to have a vote. And you have to have notice, right? So the title of applicability in the act applies only when each of the conditions is satisfied, including the local government establishing procedures and requirements. So you have to follow all the requirements for enacting a ordinance. To be clear, the act does not compel a local government to enter into development agreements or to enter into negotiations with a developer. But if a district decides they want to use this to enter into an agreement, then you must satisfy all the conditions of 163 and by ordinance enact this on the land. So, in other words here, a government cannot enter into a development agreement on an ad hoc basis, meaning it can't just do it because it wants to do it. It has to do it following the rules that everybody else plays by. And Disney, for the longest time, wanted to play by its own rules. Oh, thank you guys. It was Conjunction Junction. I was thinking Conjunction Junction. You guys know about that. Schoolhouse Rock. You guys know how I think. So it says, it is an elementary principle of statutory construction that significance and effect be given to every word, phrase, sentence, or part of a statute. And words in a statute should not be construed as mere surplusage. What this means is that words matter. Every single word. So when you see shall, that means shall. Not may, not might. No, maybe if I feel like it. No, maybe if my name is Valiant Renegade and I send a $4.99 super chat saying, in other words, Disney effed up. Yes, they did. Yes, they did, Valiant Renegade. And appreciate seeing you in the chat. But hop on with you this week for sure, my brother. And good coverage over at Valiant's channel, growing like wildfire. So make sure to check my good homeboy out. But going on here, it says, it is also consistent with the overwhelming scholarship and practice of local governments since the act became law in 1986, baby, the year I was born. And let me tell you, I have read every single case on this in Florida because there aren't that many. And this is so clear. It is crystal clear. You need to follow everything that they tell you to do. And right here, what does it say? The word may is mandatory in the context of statutory instruction. Valiant calling me a simp. I'm only a simp for you, Valiant. Only for you and your glorious, glorious, glorious coon-ass self. Only you, Valiant. Appreciate everybody in the chat. We have nearly almost 900. We have 870 almost. Guys, get us to 500 likes. Appreciate you guys in the chat. Your support, you're supporting me in this channel. Helps me do what I do here. And go deep like you guys like. So applying these principles. So now we're going from theory to application. The university phrase may by ordinance can only be read to require that a government that chooses to consider a development agreement must adopt an ordinance that establishes the procedures and requirements for doing so. Reading the statute at issue here as authorizing a local government to enter into development agreements under the act without first having adopted an ordinance as mandated by the act would impermissibly fail to give effect to the statutory terms. So meaning you need to adopt the ordinance, you have to adopt the ordinance properly. Guess what they didn't do, guys? Spoiler, It is undisputed that they purported to enter into the development agreement under the act, but dun dun dun, RCID never enacted an ordinance required by the act that establishes the procedures and requirements to be followed by the district to considering and entering into a development agreement. Boom. Thus, they lacked authority to enter into a development agreement, making the development agreement beyond their power, ultra vires, and void. So, guys, this is such a Sigma move here in thinking about this. These guys, because they were rushed and they knew they didn't have time to enact an ordinance, what you had to do is you had to enact an ordinance saying these are the considerations we're going to think about when we think about entering into a development agreement, because a development agreement has to balance the public interest against the private gain. And you have to say, okay, we want to allow the private people to develop, but we can't sacrifice the public interest. So you need an ordinance that sets out the rules, the considerations, the requirements. That's required. Well, guess what? They didn't do that. And guess what? There's no light most favorable to Disney. There's nothing. Because there's no ordinance. Big, big, big mess up for Disney. And once again, this count alone, just like the first one, enough for Disney to lose. 3 super chats here. Or it's actually, sorry, one more. $10 super chat from Scorpio. 04. Appreciate that, Scorpio. Appreciate you supporting this channel. Even appreciate Valiant Renegade here in the chat as well. Appreciate you showing up, Valiant, and hanging out with us. But Legal Eagle said that Disney was gonna win. Oh, well, he spoke a little too soon, right? 900 in the chat, guys. Make sure you smash the like button here. All right, so we're going into the next one. We're going into count 3. We are now about halfway through already in these counts. Blazing through Florida law like a true Florida man. The district lacked authority and jurisdiction to enter into a development agreement for property within municipalities. Here's the big one. So within Disney, within this district, there's the big RCID. It used to be RCID. We're going to call it that because at the time it was RCID. But within RCID were 2 cities. And we're going to call them cities very lightly, because by cities, they were really cul-de-sac trailer parks. I know WW Pro and Valiant have also looked at this. They were some essentially cul-de-sacs with like 5 or 6 double wides on them that they called cities. But technically, legally, they're cities. So here's the thing. The development agreements purport to vest in Disney all the development rights within the district. However, 2 municipalities, the city of Bay Lake and the city of Buena Vista, are located within the district. Uh-oh, Disney. Messed up there. The majority of the property within the district, including the majority of Disney's property, is located within the municipalities. So these cities control the majority of Disney property. So RCID's authority cannot apply to them. They had to independently enact these agreements. The city of Bay Lake and Buena Vista. They forgot to do that. When Disney approved and executed the developer agreement, Bay Lake and Lake Buena Vista had exclusive authority over comprehensive planning, land use development, build-in permitting. Well, RCID had exclusive authority over the same within the district boundaries, but outside the municipal boundaries. Think about this like your city and your county. So in Orlando, Orange County has authority over the areas outside of the city of Orlando. And unless you have a city and a county that are consolidated, so those are places like Jacksonville, Florida, or Charlotte, Mecklenburg County. Jacksonville, Florida is united with Duval County, so they're kind of one and the same. Same thing with Charlotte and Mecklenburg County. The city of Charlotte and Mecklenburg County are one and the same. They're united. They're consolidated. But in this case, they're not like that. They don't operate like that. They're separate entities operating separately, not consolidated. Therefore, because of that, they cannot exercise their authority within those districts. And because of that, those agreements are illegal inside of Disney property, inside of the property, majority of Disney property, because that's within the city of Bay Lake or Lake Buena Vista. Neither Bay Lake nor Buena Vista held public hearings and signed the development agreements. Neither joined the development agreement as to party either. And RCID did not sign the agreement on their behalf. So they didn't have delegated power to go ahead and sign those on behalf of those other governments. It was not a thing. Because RCID lacked the authority to approve or regulate proposed development within the boundaries of Bay Lake or Lake Buena Vista, and because these municipalities did not conduct public hearings, ruh-roh, Scooby, and join as parties to the development agreement and restrictive covenants that depend on it are void and unenforceable as a matter of law. Completely unenforceable. Moreover, Disney's severability provision cannot salvage this. So severability says, hey, even if part of this is invalid, we can stay legal. That's what severability. You'll see this in a lot of contracts, even your regular contracts. So any provision held wholly or partly or unenforceable shall be deemed amended, and the court or other body is authorized to reform the provisions. So this severability can usually save agreements. But here, it's triggered only when a provision or application of a provision is held invalid or unenforceable. However, in this case, the entire development agreement is illegal over the property within the municipality's borders. Thus, the development agreement in its entirety, not merely a provision, is invalid or unenforceable. So the entire thing will be bunk and cannot be severed out and broken out from the underlying agreement. Let me get these here because a couple of you guys did some really cool stuff in the chat here. So let me just Michael Pate, welcome to the RPG, and Lele, appreciate you for gifting 20 memberships to the chat. Appreciate y'all. Appreciate y'all very much. Appreciate y'all very much. Thank you so much. And here we go. Good logic coming in from the bleacher says, we get it. Groomer Mouse is going to be squatching at a DeSantis booth. I'm almost home. Read faster and direct. Fuck you, good logic. I love you, buddy. Drive slower. Have your wife drive slower. Have your wife drive slower, good logic. I'm joking. I love Joe. I can't wait to hang out with Joe again in the near future. Joe, I'm gonna hit you up, baby. We gotta get our mojo back. Next week, baby. Love you. All right. Ted Park says, are there any people that were judges for Florida on the CFTOD team? Just asking. Try Ted Park. The lawyer that wrote this was the Supreme Court Justice for Florida. The lead attorney, Alan Lawson, was a former Florida Supreme Court judge. This guy knows Florida law. He knows Florida property law. He clearly is citing the right law for special districts. So the district did a good job of hiring people who know their stuff. They did a good job. The Disney, on the other hand, they didn't hire anybody who knows Florida law. Look, if they'd thrown a couple million my way, I'm saying I might have given them a 30-minute consultation. They can get 30 minutes of my time. That's about it. And I may tell them to go pound sand, but just saying. They didn't pay the right people. Paid the wrong people. And also LMFAO Joe, yes, we are all laughing at Joe. We are all always laughing at Joe. Just point that out here. All right, continuing here. Vesting in Disney, the universe of development rights within the district, committing the district to finance and construct infrastructure relating to Disney's development activities, and removing the district's regulatory discretion over all Disney's property located within the district is the purpose of the development agreement. Inclusion of the property within the municipal boundaries is non-divisible from that purpose and not subject to severability. So they can't break out the district property the city property from the district property. The agreement was meant to cover everything. You can't break it out. As the restrictive covenants expressly and entirely depend on the unconstitutional development agreement, they are likewise void and unenforceable. Therefore, they're entitled to judgment as a matter of law in count 3. So the purpose of the development agreements is defeated here. What they did was beyond their powers, and therefore, boom, invalid. All right, 3 down out of 5. So we're already at 4. Darren Bennett said, we would love to meet up with you. My wife Fatima and our son Hodave said, yes, we meet him at Cebu Airport. Stay at the Bella Vista Hotel. Awesome. Yeah. Look forward to going to Cebu, and I'll take the hotel recommendation. I always love travel recommendations from anybody. So really appreciate that, Darren. All right, let's continue here. Act 4, violation of the Florida Constitution. We're talking about Florida constitutional violations here. And just checking in, make sure everything's all kosher on my locals. They're behaving themselves for now. Okay, so how did they violate the Florida Constitution? The development agreement requires the district to levy and collect ad valorem taxes from district taxpayers to finance bonds. Oh no, guys. Oh no. Oh no. It's once again my area of specialty, bonds. The most boring thing ever that I never dreamed in a million years I'd be streaming about gosh damn bonds. About bonds. Bonds are supposed to be boring. You know, the only time I thought bonds were sexy? In The Big Short. I actually rewatched that movie a while ago. The Big Short, like, very good. But it's like bonds are normally very much not sexy things. They're very boring, especially local government bonds. These dirt bonds. They're extraordinarily boring assets. I like that. What's your name? Bond. Disney Bonds. I like it. I like it. Brandon says, I like a nice slow read. It's also a good audiobook for Lady Logic to listen to over the shrieking coming from her passenger seat. The wailing of the true female in the car. Very true, Brandon. Very true. Let's continue with this in a very slow and melodious pace that will definitely please all involved. The development agreement requires the district to levy and collect ad valorem taxes to finance bonds used to fund certain capital improvement projects exceeding a 12-month period. Full stop. Full stop. You cannot require somebody to force them. You cannot force a government to issue bonds. If they want to issue bonds, they're going to issue bonds. But you can't force them to do that. And certainly what you definitely cannot do is force them to issue general obligation bonds. There are 2 types of bonds. There are revenue bonds and general obligation bonds. A revenue bond pledges very specific revenue. Typically, this will be like a highway bond. So a highway, if you want to build a highway, you raise money through these bonds. These are, issued to large people buying them out, probably your BlackRocks, your Oppenheimers, your big institutional buyers, which will buy these bonds, and they'll get a payout a coupon. They'll get a payout over 30 years on these bonds. And they'll be paid out on the highway bond with the highway tolls. So if you drive on the turnpike, you know the Florida Turnpike collects toll money. So that toll money is often used to pay back bonds. Now, a general obligation bond is different. What that is it pledges the full faith and credit of the government, which means you have to raise taxes as much as possible, as much as they ask for to pay for those bonds. That requires typically a vote in most places, or a higher level of scrutiny than just a simple revenue bond. So the infrastructure project listed in the capital improvement schedule that will be funded, designed, constructed, or cost to be constructed by the district in order to facilitate the implementation of levels of service to the maximum development program. The translation into English here, guys, means Disney had a wish list. We'll call it a magic pixie dust list of stuff they said they're going to build, which probably, knowing Disney, especially if you guys follow Valiant and you see how much money Disney has been losing, Disney is probably saying they're going to build it. They're pledging, like Amber Heard pledged donation money. They're pledging money, but they're never going to build it. But what they're doing is they're saying, well, we think in our pixie dust world, we think we're going to build these things. And because of that, you need to issue bonds and raise taxes to pay for these things. Even though we may never build what we're going to build, you have to do this. You must do this. Yeah, that's illegal. They have no authority to qualify those bonds or direct the issuance of those bonds. They have to be separate. That's one of the biggest requirements in the bond world, is that the government is operating separately and independently. Hotep says, for $1.99, salute from Hotep.com. What's up, Cannon? Make sure to say hi to Hotep Jesus, all the other Uncle Hotep, all the other OGs out there at Hotep.com. Appreciate you. And appreciate Leprechaun Gold coming in for $50 with a super sticker. Was it yeah, appreciate your super sticker. Really cool. And Matt Mupp for 20 said, come on, everyone, hit the like button. I'm on vacation and hit it. Preach the word of Andrew, brother, and the mouse may be smited and smote. What's up, VR? I see you trolling back there. We all see him. We all see him. He's in the peanut gallery where he belongs. We know what's up with that. So right here, it says there's a schedule for road projects, dun, 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 that they wanted to require be funded using new bond funds. And how much? Hold on, guys. Hold on. Am I reading this properly? Can you guys see this? $300 million? $300 million. They wanted $300 million from the taxpayer on this. And on top of that, after they give them the 300, they want an additional 240. These guys want $500 million. $500 million in bond funding. Ridiculous. This is future bond. I like it. So like one shitty movie. Yes, except that's like their losses on one shitty movie. Right? Some guy with cancer says, I've been on fentanyl and still made more sense than Disney legal and their fanboys. Oh, wrecked. Sorry, I'm dying. Oh, that's funny. That's actually really funny. Okay. Valiant, it's all your bonds belong to us. So Act 7, Section 12 of the Florida Constitution says that the district that allows the district to issue general obligation bonds only. So you can only issue bonds when you have a vote of the electors who are owners of the freeholds, not wholly exempt from taxation. So they needed a vote. They never got a vote to do this, to authorize this. And by the way, guys, this has been in the Constitution for a while. So much so, this was on my bar exam. This is basic knowledge for a Florida lawyer. I know it may be out of people's mind. And you're like, if you've been practicing for a while, like my good friend Stephen Gosney, you may have forgotten that. But this is like 101 for bonds, is that you need for general obligation bonds that are paid out over more than 12 months, you need to have a vote, an electorate vote. That's why nobody ever issues GO bonds. Nobody ever issues general obligation bonds because no one wants to vote. Like, you're going to put out a vote there that says, hey, guys, you want to pay $500 million to Disney? People are going to say no. Of course they're going to say no. How many pole dancers does that cover? A lot, even in America. And thank you, Leprechaun Gold, for another $50 super sticker. Appreciate you. With the Shiba. Always like cute Shibas. And appreciate your support of this channel. Guys, without your support, Homeboy couldn't do this. So I really do appreciate it from all of you. There's 964 of you in this chat right now and 589 likes. Let's get to 600. Let's do it. 10 more likes. 10 more likes. All right. So now, the development agreements purport to require the district to fund, design, and construct these road projects. But this can only be done by requiring the district to issue new general obligation bonds secured by the district's ad valorem tax revenues. Because the development agreement would eliminate the district's full budgetary flexibility and instead compel the district to pledge ad valorem taxes to comply with the agreement, it creates a general obligation debt for more than 12 months. The development agreement's unconstitutional pledge is inseparable from the agreement's express purpose to provide long-term development to the property and provide necessary public facilities to RCID that will be in place concurrent with the program. So with what Disney wants to do. And like I said, this means that the government would have to build this stuff before Disney expands. Before Disney expands. So they would have to go out here on a limb, raise that money, build, and then hope that Disney expands, which Disney may go and renege on. There is no other way to parse the development agreement. Not only are the capital improvement projects identified as part of the development agreement, but the agreement further provides the projects are necessary to provide for the program. As the restrictive covenants expressly depend on the unconstitutional agreement, they're likewise void and unenforceable. Therefore, they're entitled to a matter of judgment as a matter of law on count 4. So there we go, 4 out of 5. Once again, guys, any one of these is enough for Disney to lose. Have I convinced you yet? And once again, we go back to light most favorable to Disney, steel manning Disney. You cannot steel man Disney here because they didn't do it and it's legally required. So you can't even make an argument that they did it. They didn't have a vote. There was no vote. So they just can't even argue this point. There's no dispute of fact. They didn't do it. And now the last one here, which is one of my favorite ones, which I've been talking about forever. And this is one I spent so much time on, so much time telling HOAs when I was representing special districts to pound sand. The unlawful delegation of governmental authority to a private entity. Yes, yes, yes. See how many citations they have here. This is the big one. You cannot give a corporation government power. So it says, as noted, Florida law prohibits a local government from contracting away its discretionary legislative power. It says right here, there's a long-standing principle that a municipality cannot contract away the exercise of its police powers. By the way, police powers does not mean just the power over police. That means it's broad powers. It's kind of local powers, not just the power for cops. For example, the principle of contract zoning, whereby a local government agrees with a private landowner to rezone property for consideration. Consideration means money. So to rezone property for money has been disapproved. So you can't bribe the government in order to get your property rezoned. That's illegal. That is quite illegal. Addressing the prohibited practice of contract zoning in the context of a development agreement, the 5th District held that in Morgan, by obligating itself to support a private landowner's rezoning, the county had contracted away its discretionary power as the final decision-making authority. Here, Disney's agreements are even more egregious than contract zoning, which Florida courts hold impermissible. The agreements do not merely freeze in place existing land developments. Instead, they substitute Disney as judge, jury, and executioner, final authority on all land use decisions for landlords within the district for the next 30 years. And because the very point of the agreements is to cede authority to Disney and simultaneously remove all Disney's discretion, therefore the agreements are void and unenforceable. And they're going to go into how they get these powers, how they're void and unenforceable, and how they delegate those powers further. So first, they say they violate this law in 3 ways. First, it elevates itself by providing that it shall prevail if there's any conflict between the development agreement and the district's land development regulations, so that the development agreement rules over the district. That means that if there's a conflict with the comprehensive plan or land development regulations, they're saying Disney's rules are going to trump, Disney's illegal agreement would trump the law. And that's not okay. You can't do that. Private law cannot trump, or private agreements cannot trump the law. Second, the development agreement cedes its governmental functions that the Florida legislature expressly authorized RCID and only RCID to perform, including the power to regulate every other landowner in the district. So by giving all those rights to Disney, and by having to get prior written approval from the rat, from the mouse, before developing anything. Like I said, guys, they want to build a bathroom. They have to go to Disney and get permission. And guess what Disney's going to say when they want to build a bathroom? You guys know what they're going to say. You guys know, hey, is that bathroom gender neutral? Do you have a gender neutral sign on that? Do we allow Apache helicopters in that? Are they allowed? Cat people? Dog people? Horse people? Are they allowed in there? If not, Disney's not approving that. And of course, that's ridiculous. You can't have that. But the Florida legislature empowered RCID to regulate, restrict, and determine the density of the population, the use of the buildings, structures, and land. So they had land use authority. The district, the government was supposed to have that. There's supposed to be a separation between public and private. But Disney, operating all these years, this thing as a sham, as a corporate kingdom, as an alter ego, they got high on their own supply. They thought they could get away with just giving these powers to Disney. The development agreement thus purports to make Disney the zoning authority for itself and all other property owners within the district, thus exceeding the permissible scope of development agreements, which only a local government and developer can enter into for specific purposes over real property in which the developer has a legal or equitable interest, meaning property they own. You cannot enter into an agreement on property you don't own. That's like you're entering into an agreement about your neighbor's property. And Brandon, 100% agree with you here, my friend. The resolution of bonds after this are going to cause a shitstorm. Yes. Yes. This is going to be an absolute securities shitstorm. 100%. Valiant says, Walt Disney World cannot put a gun to the puppet's head and force them to turn over power to a private company. BS, I say. Totally worked in RoboCop. It did work in RoboCop. Prefer Judge Dredd, though, over RoboCop. RoboCop was a little stiff for me. All right. Third, the development agreement eliminates the district's authority to periodically assess its planned projects. Instead, it requires the district to fund, design, construct public facilities to accommodate Disney's future growth, and requires the district to commit future ad valorem taxes to do so. This contrary to Florida law, mandating the periodic reassessment by local governments of their planned projects. So you have to go through a regular review of your comprehensive plan on an annual basis, and you have to do a 5-year plan. By the way, 5-year plans, super socialist. I don't know why we do them, but they're in the government. 5-year plans remind me of Stalin, but whatever. We'll continue here. We're legally required to do them in Florida. Further, Section 163 directs a local government to evaluate its comprehensive plan to determine if any amendments are necessary to reflect changes in state requirements every 7 years. But they can't do that. The local government, the district, isn't allowed to do that under the agreement. They have to follow what Disney says. And because of that, they're void. But going on to the restrictive covenants. So once again, restrictive covenants are like the thing you have on your HOA. The thing that says that you can't go live in grandma's HOA because you have to be 55 and up or 65 and up. The restrictive covenants are independently void because they also unlawfully delegate governmental authority to Disney in several ways. Specifically, they restrict the use of Disney's property to uses agreed to by Disney. They allow Disney to censor the district by precluding the district from engaging in speech on its own property about anything other than the district. So actually, the First Amendment speech case is actually best made by the district itself, saying the district isn't allowed to speak on certain issues. Remember, Disney was projecting this whole time because Disney, in its restrictive covenant, said, hey, you're not allowed to badmouth Disney and you're not allowed to badmouth Disney IP. I'm not joking. That's part of the restrictive covenants. You're not allowed to talk bad about Mickey Mouse. That's what Disney tried to put in the agreements. But yet they turned around and they filed a case in federal court crying and screaming about silencing their speech and made it about them. Is not that the perfect woke turnabout? It's always like that. It's always like that. In conclusion, Disney, a private entity, effectively governed itself through RCID for decades, does not change the fact that RCID was a government. So even though Disney was running it in a corrupt corporate way, it was still a government. Thus, it was required to abide by the Constitution, by the statutes, and by the common law, the state common law. It's undisputed that RCID has failed to in several key respects, and that renders the agreements void and unenforceable as a matter of law. Therefore, they're entitled to summary judgment on counts 1, 2, 3, 4, 5, and 6, and entitled to injunctive relief. And it's signed by Alan Lawson, once again, the former Supreme Court judge of the state of Florida. There we have it. So, guys, one of those counts, Disney loses. And what happens when Disney loses this case? Well, turn to the federal case. All of their claims get wiped out except for the very last one. So but one of the federal claims get wiped out. The only remaining one is the weakest one. And that one is probably tossed out as well because it's such a weak claim. Okay, what happens to the fraudulent bonds? Are they voided or do they become Disney debt? So when we're talking about those general obligation bonds, those haven't been issued yet. So the ones that the new agreements, the agreements that were signed this year, wanted them to issue that $500 million, those have not been issued yet. The only ones that were issued were past bonds. So, however, I've told you guys this. I think there may be some scrutiny on the past bonds as well. That hasn't come up yet, but it's possible. Now, if this was to go forward, I think there would be an issue. Even if Disney won, I think a bond underwriter would have a very tough time underwriting these bonds, issuing these bonds. I think Disney would have a very difficult time getting this money. I don't think anybody would want to underwrite these. The risk on this would be huge. But I told you guys, there's very much a possibility for Disney individuals, former RCID individuals, to be prosecuted for misuse of public funds. Once again, you need to see proof of that. But I think given enough digging, there may be proof of that if they look back in the records. So there we go, guys. That is the issue here. So what is the timetable? There should be a ruling on this. I would say within 30 to 60 days, we should have a ruling on this one. We also, mind you guys, we have a motion to dismiss in the federal case. That's going to be within 30 to 60 days. So we may see a resolution here quicker than I thought. I thought this was going to drag out for a year. It actually may be concluded way quicker than I thought, which is fantastic. Fantastic. Let's see. So I am also going to cover, guys, later today, not now, but later today, I am going to cover the TSG lawsuit. And just so you guys know, the TSG's lawsuit is the lawsuit where Disney, and I'm going to pull up the article right here real quick so you guys see it. They're being sued by a film finance partner, which claims that they literally did shady accounting. I'm going to cover this later. I'm not covering this right now, but this is going to be one I cover later. I just wanted to get this one out, get this one done, get this one out there in the books so you guys understood. This is the Disney versus Florida case. This affects the state case, which will affect the federal case, which will end up ending Florida. And I'm here to see it. Later today, my time. So your tomorrow morning, Ghazni, your tomorrow morning, my evening, I'm going to probably handle that one. So just so you guys know, that has huge ramifications for all the studios. And perhaps I'll see if some of my friends can join me for that as well. Not Valiant Renegade. He's not cool enough, but maybe some better friends. But yeah, I'll be going through that one as well later. But seriously, guys, do you guys like these lives? Do you guys miss the lives? Do you guys miss the lives right now? It is 9:51 a.m. It's hard for me to wake up for you guys in the morning sometimes, but I do enjoy this, and I'm just 929 of you in the chat, 698, 700 likes, actually. Thank you so much for getting me 700. So, yeah, appreciate that. Hulu update, not much to update right now regarding the Hulu deal. I believe they're still in arbitration. They're still not come to an agreement on the number yet. So we do not have an update on the Hulu deal as of yet. Yes, you guys saying they love the lives, appreciate the lives. I missed the Korean bathroom live chats. I may have to, I'll turn my camera towards the bathroom at some point. We will do like a Thai bathroom chat. In fact, maybe we'll do one on locals. Maybe that'll be the locals after party. You know what? That'll be the locals after party. We'll do that. We'll do the Thai bathroom locals after party. So you guys can tune in for that on my legal mindset.locals.com. For those who don't know, my locals and all my exclusive information there. I've got a lot of stuff to get into. One other thing I want to mention real quick before we wrap today is There was some people getting copyright claimed over the Debt versus Herd case. I know Andy Signori, Popcorn Planet. I believe Eric Hunley got copyright claimed. So obviously, I'm against all forms of copyright cuckoldry. I don't support that. And Netflix claiming people over footage which they stole from YouTube is ridiculous. So I'm going to stay on top of that one as well. I also am going to be reporting on a development in the Sydney Watson lawsuit, but that will come after I handle the Disney business. So it's Disney later. Sydney Watson will probably be in the next 24 hours. So a lot of stuff to cover, a lot of lives coming up. And of course, I'll try to clip this out to get into more digestible sound bites for you guys that can only get 15, 20 minutes. But until then, guys, I'm going to keep this one short. I know that there's a lot of other channels out there, and appreciate your time and attention. Appreciate all the love for you guys in this channel and support. If you have any questions, leave them in the comments, and I will catch you all on the next one, my friends. Peace. Head over to Locals.